SJC 11861, Commonwealth v. John Doe.
Good morning. May it please the court, my name is Tracy Miner, and together with Fred Bartman and Christina Lynn, we represent John Doe in this case. John Doe was a college student with no prior criminal record at all, no arrests, no convictions, who admitted to briefly touching a girl's vagina over her jeans while driving her late at night to pick up a cell phone that she had lost before at a bar. He is a student who suffers from disabilities, who has problems learning from or picking up on non-visual cues.
So is the disability somewhere on the autism spectrum?
Yes, Your Honor, that's exactly right. It's not a sexual deviance. It's a learning disability on the autism spectrum. He's also somebody who can overcome those disabilities and who can benefit and has benefited from counseling. He went before the district court judge and on a disparate plea suggested a continuance without a finding was the appropriate remedy. The Commonwealth was asking for a guilty and 5 years of probation. The district court took everything into consideration. This is a district court who spent an awful lot of time looking at the facts of this case, hearing from the victim, hearing from the defendant's counselors, looking at the record, looking at the defendant himself, his demeanor. And he found that he was in the group of defendants that deserved a quaff, a continuance without a finding. He was in the least culpable group. There's a group of defendants, the culpability range is high to low. The defendant was in the low category. And in an indecent assault and battery, it covers a range of activities, again, from the relatively minor to, throwing a girl down in the woods and masturbating on her. This was on the low level. So here is a defendant that the district court found was the least culpable, and the circumstances of the crime was the least culpable. So he allows him to have a continuance without a finding, which of course, as this court knows, relieves him of a lot of the collateral consequences of a conviction. The issue was GPS. The district court looked at the statute, Chapter 265, Section 47, and said, I think it's mandatory. It says placed on probation for any offense. I believe it's mandatory. It's not without ambiguity. So what the court does is finds first it's mandatory, but then with the consent of both parties decides that he will report the question to the appeals court. He then, and the record is clear, goes through an analysis of whether the GPS should be stayed, the condition should be stayed pending appeal. And again, he hears from extensive testimony from the defendant psychiatrist and counselors that say that the imposition of this GPS, this device that's physically attached to his body 24/7, was actually not only not helping his rehabilitation, but was hurting it. He was unable to go to school. He was in a heightened state of anxiety that, this beeper thing might go off at any time. He was almost to the point of being suicidal. On the other hand, they looked at the public safety issues, which are legitimate issues in any crime, particularly sexual offenses, and said that this particular defendant posed no danger to the community. He didn't have a sexual deviant behavior condition. He was fully compliant with probation. He was seeing his probation officers. He was seeing his counselors. There was very little to no risk that he would offend. So the question is GPS mandatory for every defendant who receives a continuance without a finding, and an indecent assault and battery case, or any other of the enumerated. And this court left that question open in the Raposo case. It wanted a case that could be briefed and argued on the continuance without a finding. But I would suggest that the Raposo case leads the court to the same conclusion with respect to a continuance without a finding. First, you look at the statute itself. And this is a statute that derogates rights. So this court and others have held that that you put strict construction on the statute. You don't broaden it, you narrow it. And the statute says, placed on probation for an offense. Later in the statute, it interchangeably uses probationer and offender. So you go to the normal meaning of the word offender and offense. We have some help because this court, in the connection with the sexually dangerous person statute, said offense is a conviction. This court has said in the connection with the sexual registry cases that an offense is a conviction. And I would suggest there's no reason to see it any other way. To the extent there's ambiguity, you look at the legislative history. And this court did that in Raposo. And they said, okay, this started in 2006 with a House bill that put a condition of GPS on for convicted individuals.
But doesn't the fact that, I mean, Raposo is a whole lot easier, isn't it? I mean, because
Sure.
The fact is that when you, as in this case, when you have a continuance without a finding, the defendant has admitted to sufficient facts to warrant a guilty finding, and if he messes up on the probation, that's what's going to enter.
Correct. Raposo is an easier case, but the result should not be different, even though the reasoning of Raposo, when you look at statutory construction, plays out the same way with respect to a continuance without a finding. I understand that there's no admission of anything in the pretrial probation, so when you look at that part of it, sure, it's harder in this case. But for statutory construction purposes, if the legislator intended it to be convicted individual, it matters not whether it's pretrial probation or a continuance without a finding. And I would suggest that the legislature knows, the way this court and appeals courts and district courts all know what a continuance without a finding is.
In the context of the drunk driving statutes, if a case is continued without a finding, didn't the legislature go out of its way to say that nevertheless, you still have to you still have to take the program, even if it's a continuance without a finding?
Exactly, Your Honor.
So that when the legislature wants a quaff to have the same consequences as a conviction, it says so.
Exactly. And the contrary is also true. If the legislature does not want you to be able to have a quaff, to have the intermediate disposition, the alternative disposition, on some of the sexual offenses, sexual rape of a child, rape of a disabled person, the legislature says you can't have quaffs. It could do it either way. It did neither in this case. In this case, it starts talking about convicted individuals. There's an amendment to take the probationers into the probation department.
If we can step back. The House, I gather, says convicted of any sex offense and classified as a level 2 or 3 sex offender. That's the House bill, correct?
Yes.
Senate says any person who is placed on probation for a sex offense, which is the language ultimately that prevailed, I guess.
Well, it splits it. The concern was it was internally inconsistent because parolees were going to be under the jurisdiction of the Commissioner of Probation. So they say placed on probation, and another section deals with the parolees. So.
But they also apparently included level 1.
Yes.
Sex offenders.
Yes.
Does the legislative history at all clear as to whether the intent was that this applies to persons who are sex offenders?
Yes. This whole statute only applies to the sex offense statute, to the enumerated sexual offenses. There's a list of enumerated sexual offenses,
right,
indecent
but there's
assault.
a difference between sex offenses and sex offenders.
Correct.
Because, as you noted, the adjudication of a quaff does not make you a sex offender under SORB.
Correct.
So that's,
And in the sexual offender cases, this court has said to be an offender, you have to have a conviction for an offense. And here, the statute also talked about probationer and offender interchangeably. Section 47, the second paragraph relates to an offender and a probationer. And my argument is that it's the same word in the same category of offenses should be construed the same.
and I guess my question is, I understand your argument based on the words, but there aren't that many words we have to work with. Do we have any legislative history that says more clearly the purpose of the legislature was that this applies only to those who are sex offenders?
Only in the sense that it applies only to those convicted of certain sexual offenses.
Only those who would be required to register as sex offenders?
This is broader than that.
Potentially.
This would
Because you
apply.
could be excluded from the registration, but you still would be eligible to be, you would still be eligible to be included in the registry.
Correct.
If you're convicted of a sex offense, the judge may say, I'm going to exclude you for various reasons, but a conviction of a sex offense would mean that you potentially could be included as a level 1, 2, or 3 offender. But if a quaff, you're not potentially eligible.
Correct.
And do we have
And-
any legislative history that speaks to that?
There is none. This was all done in a matter of actually 2 days. The House bill comes up, I believe it's on July 16th, 2006. The next day, the Senate amends it quickly. This was all done very quickly.
But can I ask you about Grady?
Absolutely.
So I take it your first argument is, since in your view the statute has at least some ambiguity, Grady would suggest it's important to avoid that Fourth Amendment problem or Article 14 problem. You need to interpret it the way that you are.
Correctly.
My question, I understand that. Do you think that the implication of Grady is that whether, even if you are convicted and sentenced as a sex offender,
I think,
but
I
part of
see
your
where you're going.
sentence is probation.
Correct.
In other words, there's a guilty finding.
I think that I think your honors are going to be facing that case, and I'd be happy to argue that case because I think Grady would apply, that it's a blanket search. Blanket searches are frowned upon. It's a very intrusive search.
So you could do it, but you'd have to have an individualized determination that
Exactly.
was reasonable in the circumstances.
Exactly. Here, we don't have to go that far. But yes, I think the logical implications of Grady is that even for convicted defendants placed on probation, you need an individualized determination. And nobody's arguing that you can't put GPS on in appropriate circumstances. The issue is it a blanket across the board, no matter the circumstances of the crime, no matter the circumstances of the defendant? Are we going to subject everybody to a 24/7 search in their homes, in their churches, in their families' homes? When this court, the district court in this case, because of the circumstances, actually did the analysis and said this is unreasonable. It doesn't help public safety. It's harmful to this defendant. Not only does it not serve societal purposes, it actually detracts from them. And I would suggest to your honors that the district courts see a lot of cases, as do the superior courts. They are the community judges. They know the difference between somebody who's made a bad decision once and is unlikely to reoffend, and the person that, I'm going to see you again someday. I know it. I'm going to do whatever I can just to help you not come back here. But they are the community judges. They make the reasonable. And under normal Fourth Amendment law, it's the superior court, the district court, the trial courts that make the decision. Is it reasonable in this circumstances? Did the Commonwealth put forth enough evidence to make this search reasonable? Here, there's no reasonableness requirement. It's blanket, and blanket searches have always been frowned on, both under the Fourth Amendment and certainly under the Massachusetts Declarations of Rights, Article 14, which this court has said gives the people in this state even higher rights, more rights under Article 14 than the Fourth Amendment. I think it raises Fourth Amendment issues. I think it raises Eighth Amendment issues as to whether this is cruel or unusual punishment. It raises 14th Amendment and Fifth Amendment concerns as to whether this is punishment for somebody who has not yet been convicted, as opposed to the quaff situation where the primary goals of a quaff is rehabilitation and public safety. And here, it was not necessary for either purpose. And this court has always said, to the extent there's ambiguity, we will strictly construe statutes that limit our citizens' rights. We will always avoid constitutional issues if it can be done. And here, in this situation, with a quaff, I would suggest to your honors, it can and should be done. Thank you.
Counsel.
Good morning, Your Honor. May it please the Court, Cynthia Von Flatern, Assistant District Attorney for the Northwestern District for the Commonwealth. The Commonwealth would ask this Court to answer the reported question, yes, that Chapter 265, Section 47 does apply to probationers who have received their probation via a quaff under 278-18. And just looking at the language of 265, 14, it specifically says a person placed on probation. It could have said a person convicted for a sex offense, but it says a person placed on probation for a sex offense and refers to the definition of sex offense, but unlike a registration scenario, which specifically states that sex offenders are people convicted of sex offenses, that's right in the definition, Chapter 6, 178C. We don't have that in this case. We have probationers.
Let me ask you the problem that troubles me. Okay, we're blessed with a thoughtful legislature, and they have enacted laws which say that if you are convicted of a sex offense, you potentially may be required to register and have the obligations of registration as a sex offender. Right. But if you only have a quaff, you may not be included as a sex offender and be subject to registration. Mm-hmm. So why should we infer that the legislature said for people who we, the legislature, determine need not register as sex offenders, they, each and every one of them, must be subjected to GPS monitoring?
Well, I think that it's rational that they could make that determination. First of all, with a sex offense registration, it's going to be for 20 years. And we know that it is restrictive and imposes some restrictions on liberty. With probation, a defendant need not be sentenced to probation. That the judge has discretion in that way, whether they give probation and how lengthy the sentence of probation is. So a person could receive a quaff and get a break with respect to, or the benefit of the doubt with respect to his record, so that if he successfully completes probation, the case will be dismissed and he or she will no longer have a criminal record. But in the meantime, you have safety for society, safety for the victims, imposition of exclusion zones on a temporary basis for as long as that probationary period ends.
But I mean, just as a matter of trying to divine legislative intent, I think the argument is if the legislature has referenced back to definitions that are in Chapter 6, Section 178C, the Sex Offender Registry Law, wouldn't that suggest that it is talking about offenders who, not only sex offense within that statute, but sex offenders who are covered by that statute?
But the legislature doesn't say that. They say placed on probation for a sex offense. They don't say, they could have said convicted, and they don't say. And they don't even use the word sex offenders, or they could have said sex offenders as defined in Chapter 6, 178C. They refer to sex offenses, but they don't refer to sex offenders. And so I think that this court can make an interpretation based on that language. The other thing about a continuation without a finding, as the court knows that, and I think Justice Bozard pointed out, if there's a problem with the person on probation, a guilty finding is going to enter. And so what does that mean? So once the guilty finding enters, that person's going to have GPS.
Right.
So...
Can I ask this, did the defendant in this case sign a probation agreement or anything of that sort, which one ordinarily signs if one is placed on probation?
It's not part of the record, Your Honor, but I believe he would have signed. And the other probationary conditions were not a problem for him, and he is on those conditions. But shortly after the disposition in this case, the defendant filed a motion to stay the condition of probation. But he had actually been on the GPS for a period of time before that condition was stayed.
No, I was just wondering how formal this is. Whether these are just terms of a continuance or whether they really are, whether it's really probation.
Well, it's not in the record his signing those terms, but I would submit that continuation without a finding, that disposition is very formal. And when you submit to sufficient facts to find you guilty, or sometimes people plead guilty, but the case is continued without a finding.
Well, ordinarily, I mean, if you're placed on probation, there are sort of statutory terms, blah, 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 blah,
Yes.
and then there are special terms.
Yes.
Is that true when you're given a continuance without a finding?
Yes.
Same thing?
Yes.
Same statutory terms as
Yes.
a regular probation term?
Yes. So a person with a continuation without a finding, I would submit it's the same as being on probation with a guilty finding, except that if you successfully complete that term of probation, your case will be dismissed.
Counsel, what do you say to your sister's argument that the legislature has pointed out when it wants a quaff to be treated as a guilty finding? They've done that with the motor vehicle cases for protection of public safety. But they didn't do that here.
It has done that sometimes, Your Honor. And 9024, and I know that statute has been amended many times, and they've made it very clear that a continuation without a finding counts as a prior conviction, and it counts. It sets up all of the mandatory probation in that case. So it has been clearly set out, and here certainly they don't add the words continuation without a finding, but they do say probation, and a person that receives a continuation without a finding can be on probation. Now, I can contrast that with Raposo, which I think was a much more difficult case, and this court went carefully through why the pretrial probation did not make sense, could not have been meant by the legislature under the statute. There is no term of probation when somebody's on pretrial probation. There is no offender. You're not considered an offender if you're on pretrial probation. That whole section of the statute that said that the fees could be waived for an offender would not have applied to a pretrial probationer. So all of those things made a great deal of sense. It also made sense that when you're on pretrial probation, there has been no adjudication of guilt other than probable cause, and so that...
It's same as with the quaff. There's no adjudication of guilt.
Well,
so if that's the test, where does that leave you?
I think the quaff is an animal of statute. It's created by statute, and it's created to give a defendant the benefit of the doubt so that they can save their record. They admit to sufficient facts, and facts are found sufficient to find them guilty, but that guilty is put aside. So it is a lot different than a pretrial probation scenario.
Well, with respect to Grady, you say this is by definition reasonable? You say it's a search, but by definition reasonable in the situation of a quaff?
Well, there have been, yes, I would say it's reasonable in the same way that it can be considered reasonable for a guilty and probation. The case, I think Guzman would say that it's rational, and I'm not sure if reasonable is the correct analysis or if rational when we consider that this is creation of the legislature. It's mandatory by legislation, but certainly there's been a determination that the GPS is rational for people on probation for a sex
Well,
offense.
but in Grady, right, it was, I forget, but second offender, it was sort of automatically by statute had to be, had to have a GPS, and the court said, no, you can't do that.
Well, they sent it back for a determination about reasonableness. So if that,
That would
It
mean
was
under-
not part of a criminal sentence in Grady. It was not part of a criminal
Right.
sentence.
But-
Right.
It
but
was a
here-
civil regulatory measure.
and this, we know that probation and this condition is punitive. I mean, Corey tells us that, and that's fine. Probation can be punitive, it's deterrent, it's rehabilitative, and I would submit that the GPS very well serves all of those functions.
Even if, I mean, the judge made some pretty compelling findings about the effect of this requirement on this particular probationer. What if he died because this was just so awful for him? That'd be okay? It
Well,
would be
he-
reasonable? Because it's generally reasonable?
Well, that's what, there were findings that the judge made in this case based on the testimony of his psychiatrist. I mean, you know, knowing what the judge knows, that perhaps probation or for that period of time was not the appropriate, an appropriate sentence for this individual. You know, and when this individual first originally admitted to sufficient facts, there was a question whether, and there still is a question whether the GPS is mandatory. So, you know, people have to operate in knowing what the law requires as to what kind of a disposition they're going to submit to
No,
or ask for.
I get that. I'm really going to, I think your point is, the legislature is permitted in this the Fourth Amendment would apply, but the legislature is permitted in this context to make a global determination that this is it's a search, but it's a reasonable search by definition.
Yes, that would be the Commonwealth's argument. And you
And I
know,
take it when you're on probation, your liberty is quite conditional, as are all kinds of privacy issues.
that's right.
Very
And I would say, you know, considering the purpose for probation, it really doesn't matter if a person gets a quaff to save their record. Maybe they're a first-time offender, but they're still admitted to committing a sex offense. The purposes of probation are exactly the same, whether one has a quaff or a guilty probation in that case. So I really don't see the difference there. And, you know, then we can contrast Commonwealth versus Hansen H., which this court, you know, very carefully looked at the statute and whether one could interpret it to apply to a juvenile under Chapter 119 and found that it didn't make sense. Looking at all the terms of the whole statute, it didn't make sense because we talked about exclusion zones for an offender, meaning the schools, and how could that apply for a juvenile who has to go to school. And we talked about the purposes for the whole set of juvenile statutes and that the primary purpose is rehabilitation. So I think that Hansen H. is clearly distinguishable. I think Raposo is clearly distinguishable. And in the case of a continuation without a finding, and one thing about when somebody submits to sufficient facts, they go through an entire colloquy. They have all of those rights that they're giving up are explained to them. It's a very formal and serious giving up of their intra-trial rights, their right to confront, their right
It is essentially handled as a guilty plea.
It's
for all
handled as a
practical
guilty plea.
purposes.
And the only difference is that disposition. The defendant gets the benefit of the doubt, but I would submit where the statute is worded as applying to a probationer who's committed a sex offense, that it clearly applies to the continuation without a finding. If there are no further questions, the Commonwealth.
If I could, just going back to the
Sure.
legislative history.
Yes.
Do you agree with your sister that the ultimate language was designed to avoid the term post-release supervision, and there's one statute for parole and another statute for probation?
I think that's been explained in Raposo, and I think it is difficult to read the history I have a great deal of respect for all of the things that go into it, but I think that even our case law explains that there was an issue about dealing with the parolees who have been convicted and are now on parole, and who's going to supervise them, and then people that are on probation and how they're supervised.
Because the ultimate bill is broader than the House bill, in that it includes, at a minimum, level 1 sex offenders, which were not part of the House bill. Is there any view that there was any thought or discussion about the expansion of the scope of those who would be eligible?
Well, certainly if level 1 sex offenders are included, then one would be led to believe that the legislature is very seriously considering the issue of sex offenders and protecting the public. And I think that that's certainly what GPS does, certainly with the exclusion zones. And when you put somebody on probation, you're taking a pretty good leap of faith versus probation versus incarceration. But allowing the probation with the GPS really allows that person to have more liberty than incarceration.
All right, thank you.
Thank you.